Good evening, ladies and gents, and thank you very much for joining us this evening. We've just come out of Child Protection Week, and we are currently in Youth Month. So what I thought I would do was present a case study, and I'm really just going to go through a set of facts, and then the big idea after that is to engage in a conversation. So I'm not going to be presenting for very long, average of about 20 minutes. And once we get through the presentation, my encouragement is that we engage, because the challenge with child protection work in South Africa in particular is the question of what is in the best interests of children. And we have a range of mandatory reporting clauses. We have legislation that governs what we need to report to whom and when. And the overarching thought process we need to engage in is, what is the purpose of reporting? And this case study looks at a variety of points of entry. So in other words, getting into the child protection system, what do we look at as points of entries, particularly when we have resistant and or reluctant clients? So the overarching idea is to get people to think about how to intervene in child protection. I'm not expecting people to know the details of the law. That's something that there is a handbook for, and it's something that even I and my colleagues who've been doing this for a long time, we even go and look up in the law. So I don't want you to get bogged down in the details of the law, but rather about how we think about the work as it emerges. As soon as I can get my thing to move down, which is a bit odd. There we go. Right, so the context of this is that this is a case that was actually reported to a colleague of mine, mixed with a case that was reported to me, so that we can maintain the confidentiality of the young person, mixed in with things I've added just to add a little bit of nuance and texture to the case. So the first thing to note is that this is a 13-year-old girl in grade 6. The important thing about that piece of information is that if you look at her age for grade, she is a young girl who's a little bit old for the grade that she's in. And if we look at the age that she would be if she was in grade 6, she's somewhere between 11 and 12. Grade 7 is 12 to 13. And when we look at the ages of consent for certain things, we need to consider not just the child's chronological age, but their developmental age. She comes from a disadvantaged background. And when we talk about disadvantage, the thing that is most sort of important or most relevant to think through around disadvantage is that the one thing we do know about poverty is that it limits opportunities. And in addition to that limitation, it limits access to resources. So we know that this young girl is a little bit behind academically, and we know that she comes from a background where she doesn't have massive access to resources. So she's currently, according to her school, an average learner, which means her grade for age, as I said in bullet point 1, is around 11 to 12. And significantly, she's resident at a boarding facility. Now, the information around the boarding facility is relevant. First of all, the reason we would ask is, why is she in boarding? And there are many reasons she could be in boarding. But more importantly than that she has access to another set of adults in her world where she is currently resident, the locus parentis concept. Then we get a report from the school on referral that she is socially inappropriate. Now, I'll ask people generally, if we're not doing a Zoom talk, but we're in public, and where I can see you and you can answer questions, I would say, what does socially inappropriate mean? And if a referral is made to me where they say a young person is socially inappropriate, it actually doesn't mean anything, because I don't know what people are talking about by labeling something as socially inappropriate. I would much rather that people describe the behavior. So the behavioral description they give to me is that she's a very parentified child. So within the context of the boarding facility, she likes to look after other children. She likes to associate more with the older people, which are the hostel people, the hostel mothers, the care workers, the teachers, etc. And she struggles with her same age peers. So she's quite parentified. She lives alone, when she's not at the boarding school with her father, because all of her other family got sick and died suddenly in Zimbabwe. The importance of that is twofold. The first is that the child is obviously bereaved, and we know from good research by someone like Dr. Lucy Kluwer that young people who have lost their families to HIV suffer quite a significant complex PTSD, which is higher than other forms of trauma, where young people, for example, watch their parents die from cancer. So we've got a young person who is bereaved, and on top of being bereaved, she is also quite traumatized. We know that she has then been moved from Zimbabwe. She doesn't have any female figures within her immediate family environment, and she's lost that set of nurturing other female family members. Dad is in the country legally, but the important part about it is he's temporary. So he's in the country based on the fact that he's got a job, he works in the retail environment, and he has got a temporary permit that allows him to work here for us. So he's not an illegal person. He's a person that's here with permission, but it is temporary. But the most significant thing about her move from Zimbabwe is that she sees a future in South Africa, and in fact has very little memory of being in Zimbabwe. And based on the history of everybody getting sick and dying suddenly, dad living in South Africa, her being at school in South Africa, she doesn't really have any sense of going back to Zimbabwe, which becomes very important later. She's absent from school for an extended period in the previous term, which was March. So there was a time where she didn't come back to boarding, she wasn't at school. And the question we have to ask is, why is a young girl like this not at school? And when we look at the mandatory reporting ages for school-going children, we see that this is a child who is mandated to be at school based on her age. And when we look at the reporting around that, we need to see where we could have potentially picked this child up a bit earlier. Now, in the next term, which now was last month, in May, she confides in a coach at the school that she's worried that she's not menstruating. And her history of her menstruation is that it was previously regular. And then we have to look at the triangle of care for these young people. So if I ask you, if we were in a public forum and I'll say to you, well, why would she not be menstruating? The first thing that comes to people's minds is that she's pregnant. So one of the reasons women stop menstruating is that they fall pregnant. Other reasons are eating disorders like anorexia, which causes amenorrhea. There's obviously hormonal issues, gynecological issues, and then there are things like stress that affect menstruation. So the point of entry at this point is a medical condition. She's coming to you with a medical issue, and we need to work out medically where she is so that we can decide on the next step. She asks if she can go to a doctor. And this is where, in the Children's Act, the ages of consent become relevant. Because the age of consent, as opposed to capacity, which I'll get to later, the age of consent for medical treatment is 12, but the significant thing is it is and of sufficient mental capacity. So on the birth certificate, this young lady needs to be 12, but you also must have the relevant mental capacity. And the mental capacity we look at in relation to the school is we have to be quite careful because she's a little bit behind academically. So we have to pay attention to her mental age, not just her chronological age. But ultimately, she says that she's going to go and see a doctor because based on the conversation with the coach, she needs to work out why she's not menstruating. Significantly, she says she has no other support but the coach. And that needs to be a very big warning sign to people, because when a young person in a boarding facility who comes from a community says, there's nobody in the world but you, we need to sit back and think very carefully, because how is it that this young lady has nobody to talk to except you? And that she significantly, as a result, says to you that the interaction must be kept secret. Now, based on both the Children's Act, Section 110 and Section 54 of the Sexual Offences Act, we need to be very clear that we can never, ever promise children blanket confidentiality. So the standard answer, or the standard reply, to a child asking you this is that, you know, I realize what you are wanting to tell me is obviously very important, and you're worried about what's going to happen when you tell me. But I need to say to you that there are certain things that if you tell them to me, I have to ask other people to help me. And we use a behavior influence technique called appealing to higher authority. And we say that the law says that sometimes we have to get help. And if they ask for what, that's obviously if they're being hurt, so if they've been abused in any way. The other one is if they're going to hurt themselves, which becomes apparent later. And then the other one I put in is that if crimes are being committed, because there are certain crimes we also need to consider mandatory reporting around. So at that stage, she says, well, she's not going to say anything to the coach, and she decides not to go to the doctor because of the mandatory reporting clause, which she understands, and she does a home pregnancy test. She then confirms that that pregnancy test is positive to the coach. She also discloses, which becomes relevant in terms of ages of consent for sex, as well as criminal capacity. She discloses that she has a 15-year-old boyfriend who she has had consensual protected sex with. Now, in terms of the mandatory reporting clauses under Section 110 of the Children's Act and Section 54 of the Sexual Offences Act, we need to recognize that the sections 15 and 16 of the Sexual Offences Act were made unconstitutional, and essentially those were the sections that criminalized consensual sex between children 12 to 15. So what the Constitutional Court found in the Centre for Child Law and Teddy Bear Clinic and others is that they found that if both children are between 12 and 15 and both consent to the sexual contact, it is not a crime. That doesn't mean we do nothing. It doesn't mean we don't offer family planning services or sexual health services or therapy services. It just means we don't have to report it to the police because there can be no criminal outcome. And significantly, if the one of the children turns 16 and the other one is 15, it's still not a crime, provided that the person who's over 16, which is the age of consent for sex, is not more than 2 years older than the person who's 15 and younger. So in other words, if it is a 12-year-old having sex with a 16-year-old, that is a mandatory reporting clause. But if it is a 15 and 6-year-old, it's not. 15 and 17-year-old not, and 14 and 6-year-old not, because the minute they turn 16, they can consent to sex, except online sex, which is child pornography. We don't have to report it. Okay, but if the age gap is more than 2 years, we do have to report it. If that young man, for example, is 2 years older than him, he's 17 and she's 14, even though it's consensual and a crime is being committed and we do report it, we deal with him in terms of the Child Justice Act, which I'll get to a bit later and was the subject of my previous conversation. But in that sentence, if you are dealing with a young person like this, the most important thing in that sentence is she clearly says that the sex was protected. So somewhere in that, she's telling us that she doesn't believe that her 15-year-old boyfriend is the father of her unborn child. She is a bit worried because they did exchange naked selfies, which is technically a crime, but is dealt with in terms of restorative justice because they're both children. And she's then referred by the coach to a clinic. And there's a confirmation that on the blood test, there's a confirmation that she is 9 weeks pregnant. Now, the term of the pregnancy is incredibly important when we are doing option counseling. So essentially, the options for a young person like this is that they can keep the child, they can put the child in foster care, they can give the child up for adoption. There's obviously familial care that comes into play. And if she chooses a termination of pregnancy, what must be understood is that it is not the age that is relevant in terms of consent for a termination of pregnancy. It's the term. In other words, it's the trimester in which she finds herself. So in the first trimester of a pregnancy, there is no age of consent for a termination. It is based on the conditions. So age is not relevant for a termination of pregnancy in terms of consent, but the trimester of the pregnancy is what is relevant. So in the first trimester, as I said, there is no conditions. So any woman can terminate at any time for any reason in the first trimester, as soon as she has fallen pregnant. When it comes to the second and third trimesters, it needs to be recognized. When you just mute yourself there while you're walking, there we go. When it comes to the second and third trimester, it's important that what happens is they just add conditions for the termination to be granted. They don't actually, they don't add age. Only when you cross-reference it with the Children's Act and the Choice of Termination of Pregnancy Act do you have to then see that for a medical procedure, which the later terminations are, you need to be 12 to consent to a medical procedure. And the medical procedures that follow in the second and third trimesters are important. So by way of a quick sort of interjection of a case study there, I was referred a young lady of 15 who was being charged with murder from the Johannesburg Regional Court. And they sent this young lady to me because she had fallen pregnant. She had then gone to one of these guys who advertise on the street poles in Hillbrow. She had taken the gastric medication. She had then, they told her she would miscarry, but she had given birth to this child, and they told her the child would be stillborn. But she put the child in the bucket they use for the toilet, and the grandmother found the child, and the child had actually breathed. The child was at one point alive and then had died in the bucket. And because the child was older than 26 weeks, which is the legal age at which children are seen as legally viable entities, and had taken a breath, the child was considered to be murdered. If that child had not taken a breath, that child would have been a concealment of birth if they concealed the birth. And that young lady was referred to me for a whole range of services from the court because she was dealt with in a restorative way based on the fact that she had been made pregnant by an older person and subjected to this illegal medical practice. Okay. So fortunately, they didn't do that with this child, and they referred this child to a tertiary medical facility, which is the appropriate thing to do. She's a young girl. She needs to have proper medical care. She needs to have proper option counseling for her pregnancy. And at that stage, she requests an HIV test because she says that based on her history, that she would like to know her HIV status because that's going to be a consideration within her decision as to whether she terminates or not. And the HIV test is positive. The age of consent for an HIV test is 12, and it's what we call an or clause as opposed to an and clause. So medical treatment is 12 and of sufficient mental capacity, but an HIV test is 12 or of sufficient mental capacity. So sometimes younger children are able to have HIV test, provided that the pre-test counseling shows that they have the sufficient understanding to give informed consent. And it's being used in schools quite a bit, which is causing some issues around what we call the 90-90-90 campaign. So the campaign wants 90% of people tested. Of the 90 tested were positive, they want 90 on treatment, and of the 90% on treatment, they want 90% to be virally suppressed. So there's a big issue around HIV tests and ethics, which become a bit of an issue later. So here's where it becomes really complicated. She then says that in that period that she was absent from school in the previous term, her dad had taken her for another TOP because she had been pregnant before, and she doesn't want him to be informed as he beat her the last time. Now, here we start getting into a world where we're saying, all right, you know, previously we didn't know why she wasn't menstruating. If she's pregnant and she's 14, we need to consider whether she was abused. We hear about the 15-year-old boyfriend. That's not a mandatory reporting clause. But now we're suddenly in a world where she's been pregnant before, but her dad's beating her. And he, in fact, had said to her, you know, the reason he's beating her, she should have taken care of the contraception because that's a woman's job, and that he's, in fact, disclosed to be the father of both of her unborn children. So what has happened in this particular context is that with her becoming quite parentified, he had actually replaced his wife, who was deceased, with her. It was just him and her living in the house alone, and he had literally started treating her like his wife. Now, when we spoke to her and said to her, look, you know, there are now laws that govern what we need to do, she says, if you call the police, I'll tell them I know nothing. If you call social workers, I'm not going to cooperate with them because I don't want my father to go to jail. If he goes to jail, I'm going to get deported. I want to stay in this country and I don't want to be removed from my dad. And I love him very much. He's a good dad, but he needs to stop abusing me, which is not uncommon in these incest cases either. So she tells the counselor she now wants to leave school, which we know she cannot do because she is not yet 15 or in grade 9, so she is legally mandated to be at school. But we can see the bargaining starting to emerge. She now has been parentified, she's been treated like an adult, she's bargaining as to whether she wants this child, and if she's going to keep the child, she's going to need to support the child, so she wants to, but she can't. Now, she then says, I don't want to speak to you anymore. Now, as much as at 12 she can consent to the counseling, she can also refuse to see us, which makes her a reluctant or resistant client, which creates some quite big challenges for us because it's not a young person who's willingly coming to us. And she wants to know, should she tell her boyfriend about the HIV? Now, the answer to that is yes. And in fact, there are HPCSA ethics rules that if young people do, or people, not just young people, if people don't disclose their HIV status to people they are in a sexual relationship with after attempts to counsel and do many things, there is a duty to actually tell the partner. Now, we know what is going to, well, not inevitably, but we know what the most likely outcome of her disclosing her incestuous pregnancy and her HIV status to her boyfriend is, and that is he's going to disappear. Okay. Then she starts taking drugs because she says, really, I can't cope with this. So she starts taking drugs. We've got this young pregnancy, which is probably now at about 10, 11 weeks. And it's just before the cutoff for the 12 weeks for the unconditional TOP. And now she's drinking, she's taking drugs, which gives us another point of entry into the system because Section 150 of the Children's Act allows us to get children removed and placed for substance abuse treatment if they do not have the means to get the treatment. So there's another point of entry other than the fact that she's been abused. And then she says she wants to die because it's all too much. So she becomes quite suicidal and she starts self-harming and she's saying, I just can't cope with it. That in turn gives us another point of entry into the system because now she's a young person who's potentially a danger to herself. So we end up with a few points of entry. We end up with the one into the criminal justice system, which is saying she won't make a statement, which makes our life almost impossible when it comes to reporting cases, particularly because you need a statement to open a case. There is DNA from the fetus, provided the hospital has kept it. So potentially we have some kind of DNA evidence related to the previous pregnancy and the current one. So we can argue that we can do that. We need to report to social workers, but she's saying she's going to resist being removed. What do we do with her? If she resists, is it like we take her away forcefully and almost like arrest her when she hasn't done something wrong? Do we take this young lady and put her in some kind of substance abuse treatment facility to make sure that we don't have a baby with cocaine problems, provided she keeps the baby, cocaine problems or fetal alcohol syndrome, so we're protecting the unborn baby at the same time? And the other thing is, obviously, if she's self-harming and she's attempting suicide or she's got suicidal ideation, we need to be very aware that we can also use that as a way to intervene via the Mental Health Act. And then finally, which I haven't put in, is that there's also an option to intervene via the Domestic Violence Act for a protection order, where anybody with an interest in the child has the ability to go to court and get a protection order on behalf of the child to put in sort of like safeguards and barriers around how the father is allowed to and not allowed to engage with her. So that's the long end of, sorry, the short end of a very long story. So what I'm going to do now is I'm going to stop sharing my screen and I'm going to open for questions and comments of clarity so that people can think through what would happen at any level of this case and how one would potentially intervene to ensure the best interest of this child, considering child participation, but also considering our duty of protection.
Luke, must I stop recording at this point? I don't know if the conversation.
Yes, please.
Okay, I'll stop recording. Here we go.